Hello, everyone. I'm Jim Turk, the director of the Center for Free Expression, and I'd like to welcome you to today's panel. It's going to be about the expressive freedom rights in universities and their limits. But I'd like to begin by acknowledging that the land on which I am talking to you tonight is the territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I'd also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaty signed by multiple Mississauga and Chippewa bands. I also want to thank the co-sponsors of today's panel, PEN Canada and the Canadian Association of University Teachers. Our panel will be addressing the question of what should be the limits to freedom of expression in Canadian universities. This is a vital question because the role of universities in our society is to advance knowledge and to educate students. As the University of Toronto's statement of the purpose of the university makes clear, a university must be, and I'm quoting, dedicated to fostering an academic community in which the learning and scholarship of every member may flourish, with vigilant protection for individual human rights and a resolute commitment to the principle of equal opportunity, equity, and justice. The statement continues, within this unique university context, the most crucial of all human rights are the rights of freedom of speech, academic freedom, and the freedom of research. And we must affirm that these rights are meaningless unless they entail the right to raise deeply disturbing questions and provocative challenges to the cherished beliefs of society at large and of the university itself. And they conclude by saying it is this human right to radical, critical teaching and research with which the university has a duty above all to be concerned. For there is no one else, no other institution, and no other office in our modern liberal democracy which is the custodian of this most precious and vulnerable right of the liberated human spirit. Now, this is, I think, a really powerful description of the context of the university and why freedom of expression has traditionally been seen to be so central to the ability of the university to fulfill its mission in society. And yet this vision of the university is challenged widely and frequently by governments wanting to direct what universities can and cannot do, as Ontario is doing in its recently adopted Bill 166, which we'll be talking about today. By politicians and political parties challenging academics' rights to raise critical questions or explore topics that they, the politicians, deem unsuitable or harmful or irrelevant. By donors troubled by issues raised in courses and faculty publications and research. By academic staff objecting to colleagues' lines of inquiry which they find repugnant. By students deeply uncomfortable with ideas they must confront in some courses or perspectives introduced by members of the academic staff. And it's hard to talk about the outside and inside threats to the university without talking about what's happening in the United States currently. You may know that last week there was an executive order that has caused the National Institutes of Health and the National Science Foundation to cancel all meetings of their grant review committees, which means that no new grants can be awarded. And then last night's announcement that that freezes all grants and that are targeted, and to assure that they all align with federal spending priorities, consistent with the in the words of the announcement, with the president's priorities. So this puts all research grants up for reconsideration by the agency before they can be released. And what's particularly offensive and surprising about this is almost everything that's been frozen was authorized and is being handled under a law passed by Congress, which the president has insisted that he has executive authority to override. So the point is, these all undermine the academic freedom rights of academic staff. Now, since academic freedom is going to be part of that, I just want to conclude by talking about very briefly what academic freedom is. It's the right of academic staff to use their best professional judgment in what and how they teach, in research and scholarship they undertake, also to have the right to comment on any aspect of the institution at which they work, and finally, to exercise their rights as a citizen without sanction by their employer. Academic freedom is an essential right academic staff need to fulfill their responsibilities to the university. And it is, as we will discuss today, not the same as freedom of expression, a general right essential for all in our society. The issues of universities and freedom of expression most recently became a very public topic in relation to the protest encampments at universities across Canada, with some of the universities, specifically York, Laval, University of Alberta, and the University of Calgary, shutting down the encampments almost as soon as they began, often violently, before students, faculty, and staff had any meaningful opportunity to exercise their charter rights to freedom of expression and freedom of assembly, raising, among other things, the questions of whether universities even have an obligation to act in a manner consistent with the charter when it comes to expressive freedom of their faculty, students, and staff. So these are some of the vast array of issues and questions that we're going to be discussing tonight. And I'd like to introduce the panel who will be having that discussion with you. First, I'd like to introduce Jamie Cameron. Jamie is Professor Emerita of Law at Osgoode Hall Law School. Her work is focused on a variety of constitutional and public law issues, and she is rightly regarded as one of Canada's leading legal minds on matters related to the Charter and freedom of expression. Welcome, Jamie.
Thank you, Jim.
Our second panelist is Louis-Philippe Lampron. Louis-Philippe is professor in the Faculty of Law at Université Laval. His research focuses on the protection of human rights in Canada and in international law. He is also affiliated with the Center for Interdisciplinary Research on Diversity and Democracy at Université du Quebec of Montreal and co-spokesperson of the Research Group on Human Rights of the Faculty of Law at Laval. Welcome, Louis-Philippe.
Thank you, Jim.
Our third panelist is Richard Moon. Dick is a distinguished professor and professor of law at the University of Windsor. He is a leading Canadian expert on freedom of expression and on freedom of conscience and religion. His most recent books, and I have to note these were all published last year, so 3, The Life and Death of Freedom of Expression, Freedom of Conscience and Religion, and a book he co-edited with Jeffrey Hewitt and Beverly Jacobs, Indigenous Spirituality and Religious Freedom. Welcome, Dick.
Thanks, Jim.
And I want to acknowledge for the audience the sacrifice you're making to be with us tonight. Dick is in England, and so it's now shortly after midnight his time. So we really appreciate your dedication to discussing freedom of expression at this hour of night. Thank you.
We'll see how coherent I am.
I'm sure you'll be fine. Our fourth panelist sent me a message an hour ago saying he was quite ill and is not going to be able to join us. That was Vershawn Young. He's professor of Black Studies, Communications Art, and English at the University of Waterloo. He's a lawyer, an actor. He's written 10 books, including Yesterday's Literacy, Culture and Education After George Floyd, Other People's English, The Rutledge Reader on African American Rhetoric, and Neo-Passing, Performing Identity After Jim Crow. So it's with considerable sadness I have to share with you that he's not able to be with us, but we'll proceed. So we want to start with a question to each of the panelists to set the stage for the conversation to follow. And what we're going to have tonight is a conversation with you that we're going to bring the audience into the conversation as the evening proceeds. But I want to set the stage for that conversation. I'd like to do so by asking each of the panelists a question. So Jamie, in my introduction, I gave a brief description of academic freedom, a right of academic staff necessary to do their jobs. Could you talk about the broader right enshrined in Section 2 of the Charter of Rights and Freedoms to freedom of expression in Canada?
Okay, I can do that, Jim. Thanks very much, and welcome to everyone who's tuned in to hear us this afternoon and this evening. So, as many of you can appreciate, expressive freedom is one of our cherished rights, one of our most prized values, and I think just to say very briefly, there are reasons for this. So that Freedom of expression, of course, promotes democratic values. It promotes our democratic governance. It gives us, as members of the democratic community, an opportunity to exchange ideas and opinions and to hold our various governments accountable. So it's a very important part of our democratic governance. In addition to that, expressive freedom, freedom of expression, and the freedom to, again, exchange thoughts, ideas, opinions, etc., supports a process of societal evolution, a process in which we're able to evolve and change as a society, and to rethink and reconfigure our ideas about political, social, cultural, economic values through the exchange of ideas. So that's a very, very important part of expressive freedom. And another aspect of expressive freedom is that it empowers the agency of individuals to pursue their own goals and objectives. So just very briefly then, those are some of the key values that are supported and promoted by freedom of expression. So freedom of expression has since 1982 been protected by the Charter of Rights and Freedoms. And the Charter of Rights and Freedoms, again, as many of you know, protects Canadians from interference by the government with their rights and freedoms that are protected by the Charter. And so I just want to make 2 points about that in reference to freedom of expression. The first is that freedom of expression is, as Jim said, protected by Section 2B of the Charter, but it is not an absolute right. Freedom of expression is subject to limits under the Charter that are considered reasonable and justifiable in the interests of democratic society as a whole. So just a couple of examples of the kinds of limits that are accepted under the Charter to freedom of expression. Some of these arise under the Criminal Code. So the Criminal Code, of course, prohibits certain kinds of expressive activities. The ones we're most familiar with are things like hate propaganda, pornography, child pornography, those kinds of things, and even the lesser known, but dangerous in my view, crime of defamatory libel. Outside the criminal law, there are other kinds of limits that are placed on expressive freedom, and these are found in the broader law of the country and the provinces. And these are things like the laws of defamation, the human rights codes that we find in all the provinces and at the federal level that prohibit various kinds of discrimination against individuals, which can be committed through expressive activities. And there are other kinds of limits on expressive freedom that have to do with laws of harassment and so forth. One thing that we often talk about when we're thinking about freedom of expression is, sorry about that, what to do about offensive expression and whether it is permissible to place place limits on offensive expression and on expressive activities that we find offensive, repugnant, the kinds of ideas and thoughts we simply don't agree with. And I guess the question we have to have in mind when we're talking about that is whether we really can prohibit ideas just because we find them offensive or repugnant. And that raises another issue, which is whether and when offensive expression crosses the line and causes harm. And in that question is a further question about how we define harm for purposes of finding an appropriate balance between freedom of expression and the protection of those in society who may be vulnerable to the harms that can arise from expressive freedom. So that's point number one about expressive freedom in the Charter. The second point I'll just raise now, because we're going to get into it a little bit later, is the topic today is universities and expressive freedom at universities. So as we'll find out, and as we know already, expressive freedom raises many issues in this context. But one of the things that's interesting is that the status of universities under the Charter remains a little bit unclear at this point in time. That is to say that there is some uncertainty about whether the Charter, including its protection for freedom of expression, actually applies to universities. Universities are not a direct arm of government, but there's a lot to be said for the reasons why the Charter does or should apply to universities. So a couple of things to think about are, what does it mean if the Charter does apply to universities? And alternatively, if the Charter does not apply to universities, how is expressive freedom protected at universities? And so just a final point that I'm adding as a matter of my own initiative, these issues came up, the issue of the Charter and its application to universities came up during the 2024 Spring Encampment Movement, which Jim has already mentioned. And I just want to encourage us as we go through the discussion to think about forms of collective expression when we're talking about freedom of expression. And by that, I mean the right of a collective entity, such as public gathering, a public protest, a public demonstration. These kinds of collective entities are actually also protected by the Charter and Section 2C in particular, which protects freedom of peaceful assembly. And I would just encourage us to remember that the rights of collective expression and those who assemble in a gathering to communicate a message are front and center at universities at this point in time. So Jim, that's the primer I had in mind. If you'd like me to address anything else at this point in time, I can, but otherwise I'll yield the floor.
Well, we'll come back, Jamie, to several of the issues about the encampments, about whether universities are covered by the Charter or in what ways they are. This is something we really want to unpack in this discussion. And I do want to say to the audience, I'm sorry, I should have said this at the beginning, the way we're going to bring you into the conversation is through questions that you have. So if you look at the bottom of your screen, you'll see a Q&A button. The chat doesn't operate in this version of Zoom, but there's a Q&A button. So at any point as you're listening to any of the panelists speak, if there's things they raise or questions you have for them or for the panel at large, just click on the Q&A button and write out your question. And then when we turn to the audience, Ange Holmes, who's the coordinator of the center, I'll ask her for the first question and she'll read it out and we'll answer it. But we really would like to have active audience engagement in our conversation. So if there are particular issues that Jamie has raised or that subsequently Dick or Louis-Philippe or I raise and you want to talk about them, please take advantage of this opportunity to raise those questions and let's generate some discussion about about the issues that are of concern to you. Now, Dick, for you to start things off, when we talk about universities and the freedom of expression on campus, it implies that the university is a singular place. But is that correct? How would you describe the differences amongst parts of the campus and how the right to freedom of expression applies or doesn't apply to each?
Yeah, I mean, I think it's pretty clear that the university, there are many sites of expression or conversation at universities, all of which contribute in different ways to the larger mission of the university. And at these different sites or locations, different kinds of rules or expectations around expression are going to apply. So when we're talking about the classroom, for example, we have a sense that certain rules of civility need to be adhered to within the classroom. The teacher has authority in the classroom. The class has a certain role or function. And so we expect some level of civility, respect, and staying on topic, for example, within the classroom itself. Something similar could be said about a meeting of some kind of administrators or governing bodies within the university, and there'd be an expectation of a certain order within those meetings. There may be certain rules that apply in the residence, for example, where students live. It's their home while they're at university, and so there may be certain reasonable expectations of privacy, of respect, of non-intrusion, and so forth within the residence context. And then we move on to, I suppose, the open spaces in the campus, and where different kinds of protest or demonstration might occur. And I think that we generally accept that in those spaces, speech can be more freewheeling. And perhaps the rules that are applicable there might be similar to the rules that would apply in the case of parks, streets, rules of time and manner, or maybe some level of respect, because there may be a problem of captive audiences on a university campus and so forth. But generally speaking, we might imagine that the speech can be fairly free and open. And then I suppose the last example might be an extracurricular talk on a university campus, a talk or an event which students are not required to attend as part of a course, as part of their curriculum in some way. And again, it may be that the restriction on, or any kind of speech restrictions on such an event should be pretty limited in character, and again, perhaps resembling only the sorts of restrictions that might be applicable in the larger public sphere. So I think it's important to take note of the various locations or places in the university environment where speech may occur and their different character.
Thank you, Dick. I mean, that really is important because there's so much talk about campus free expression and failing to differentiate between the residence, which is somebody's home, and what's permissible there and what's in the quasi-public spaces is, I think, essential to any meaningful discourse about free expression on campus. Now, Louis-Philippe, across Canada, academic freedom, as I described it in the introduction, is protected by collective agreement language that's negotiated by faculty unions with their universities. I mean, virtually all university and college teachers in Canada are unionized. I think it's over 95%. And they all have collective agreements with clauses protecting their academic freedom. But in 2022, the Quebec government brought in a law titled, in English, at least my translation of it is, Respecting Academic Freedom in the Workplace. Could you tell us why they did that, how it may be beneficial for Quebec academics, and how it may be harmful?
Those are excellent questions. So it's a pleasure to be with you tonight. Thank you for the invitation. It's an honor to be able to discuss with Jamie, Jim, and Dick, three colleagues that I have the pleasure to read since the beginning of my thesis. So I wanted to underline that. First, when we're talking about academic freedom and the debate that led the government to adopt the Act Respecting Academic Freedom in the University Sector, we're talking about the institutional guarantee that may represent academic freedom if you're looking at it through the lens of the 1997 recommendation of the UNESCO on higher education teaching. And when you're talking about this institutional guarantee, and there's a case that it may be recognized through charter litigation as a corollary similar to freedom of the press. We've been talking, me and Jim especially, about that for the last few years. It was at the center of the reflection. In 2019, the Quebec Federation of University Professors, they were reflecting about the possibility to propose a bill that would recognize academic freedom as a fundamental guarantee that would be applicable to every higher education institutions, every universities. And the problems that they were trying to address, it was about the non-uniformized definition of academic freedom through collective bargaining. So you've said it, Jim, it's 95% of professors that are protected by collective agreements, even though the definition of academic freedom in those collective agreements is not as generous from one university to another. And so there was this project to be able to reinforce for the colleagues that weren't beneficiary of a robust definition of academic freedom, a minimum definition of academic freedom that would be applicable even though you wouldn't be unionized. So that was the first problem. And there was as well some difficulties arising from the application of the loyalty obligation in labor law and trying to censor some colleagues that were critics of their own administration. So it was at the center of the reflection. And at the end of 2019, the Quebec Federation of University Professors, they just decided to try to draft a bill and to propose it to the government. And then in 2020 happened the Lieutenant Duval controversy at the University of Ottawa about the use of the N-word in class. And
Describe
then
that controversy a bit for people who aren't aware of it.
yeah, it was a professor, but it was a non-permanent professor that she used the N-word during a class. There was a complaint to the administration, and she was instantly suspended for the time of an inquiry, I
Did
guess.
she use it as an expletive, or was it in the context of a description? Do you know?
I think it was mainly in the context of, at first, a description. It wasn't in an insult or aggressive way, and they were really. And she was really, from my perspective, in good faith, trying to address the fact that some students felt uncomfortable about the fact that she was using this word in her classroom. And then the university just jumped in, and she was suspended, and there was an inquiry, and afterwards she was reinstated. But they gave the choice to a university student to attend her class or not, and then her class just decided to be empty. So this whole controversy blew over in Quebec, and then it raised the interest of Prime Minister Legault, who suddenly was interested by the question of academic freedom, which was really, really worrying. Because the fact that our prime minister wasn't really sympathetic to the concept of autonomy of university, suddenly was interested in maybe passing bills or law that would define or restrict academic freedom. It was quite worrying. And he put in place a commission. The commission Cloutier was mandated to reflect about what would be needed to reinforce the protection of academic freedom. So the worrying led place to hope, because the Commission Cloutier issued a very good, reasonable, and interesting report in December 2021. Sorry, what was that?
Just a background noise. Go ahead.
Okay, sorry. And so December 2021, the report that was mainly in phase with the 1997 recommendation of the UNESCO concerning higher education teaching. They proposed the adoption of a law that would protect academic freedom in the university, and the government decided to propose a bill on April 6th, and they wanted to pass this bill really, really fast, and it was a catastrophe. It was really, really far from the recommendations of the Commission Cloutier. It was really, really far from what would have been needed to have a robust protection, minimal protection of academic freedom. And there was a huge mobilization inside the university community, both from administrations and professors, which is really rare. And confronted to this mobilization, the government backed down and proposed the actual definition of academic freedom, which is interesting. So it's not a catastrophe anymore. There's a lot of things that have to be ironed out. There's some weaknesses, but we are able to work with that act, and it's not weakening the protection of academic freedom per se. So you asked me for the bright side and the dark side, so I'll go really, really fast, and then I'll
Sure, go ahead.
stop talking. I'm talking too much. I'm sorry. So the bright side, I would say that
The initiative in Quebec, in Canada.
but yeah, I think it is, and maybe we'll be able to talk about the Quebec Charter as well, the specificity of the Quebec Charter. So on the bright side, I would say that there is a clear clarification of the right of professors, beneficiary of the academic freedom, to criticize their own institution. So that's now in the law. So the rest of labor law has to be interpreted in accordance with this part of the Quebec legislation. I think it's a really interesting part of the act respecting academic freedom. There's a reference in the preamble of the Act to the 1997 recommendation on higher education teaching personnel, with all the links that may be done with collegiality and the two sides of academic freedom, protecting the autonomy of the institutions and the individual right to teach and do their research in pure autonomy. And there's a clear mention of the autonomy of universities in the preamble as well. And the last main topic in the bright side would be the broad definition of potential beneficiaries of the academic freedom through this act that is given to every person, not just the professors, but every person engaged in an activity through which the person contributes to carrying out the mission of an educational institution. And we're talking about university. We're not talking about high school or elementary school. It's just given to people that are involved or engaged in universities in Quebec. On the dark side, I would emphasize the fact that there's a lot to be ironed out, especially when we're talking about some limits that were enshrined in the law. We're talking about committee, institutional committee, and the mandate that can be given to those committees. Some universities decided to give the responsibility to those committees to lead inquiries about potential abuse of academic freedom, which is totally contrary to the sense of the act. But still, we have to be really vigilant about that. And as well, there has been attempt since the passing of the law from some administration to try through negotiation to diminish the scope of collective agreement definition of academic freedom that were more generous than the definition that is stated into the law. So for the moment, the unions have not conceded any restrictions that were fed by this position, but I would say that I guess that some administration will try again to say we don't need any more robust definition of academic freedom. The Quebec definition is now only what it has been defined as the definition by the Act respecting academic freedom in the university sector. And on that point, I would rest my case.
Well, so let me ask you a specific question. I mean, Laval has a strong faculty union.
Yep.
You've been involved with.
A little bit.
Yes. If there were a grievance about if there were a problem about academic freedom, would you pursue resolution if you had to choose between trying to do it through the law or through your collective agreement?
Clearly 100% through the collective agreement.
Right.
If it's an individual problem.
Yes, I'm talking about an individual problem.
Yeah, individual problem, I would go through the collective agreement because we have the chance to have a more robust definition of academic freedom in our collective agreement. But I would say that if there was problems with the financing of our institutions, then the Act would give us some leverage to be able to deal with those problems.
One of the things, just before we go on to everyone, you made several references to the UNESCO recommendation concerning this. Yep. Higher education teaching personnel. I just want to share with the audience that's the one international agreed upon definition of academic freedom. It was passed by the General Conference of UNESCO in 1997, and it has those four elements that I described as generally in all of our collective agreements. That is, protection of your right to use your best professional judgment in your teaching. Secondly, to use your best professional judgment in your research and decisions about publication. Thirdly, to have what's called intramural academic freedom, the right to say anything about the institution where you work, including being critical, because under employment law in most provinces, well, in every province, if you are critical of your employer, that can be disloyalty and you have a duty of loyalty. So academics, I guess like judges, don't have that obligation under academic freedom. And the last element that's included in the UNESCO definition and in most collective agreements in Canada is extramural academic freedom, which I described as being the right to exercise your rights as a citizen without being sanctioned by the employer. So it's a very important international definition. There have been repeated attempts to try to undermine it. It was adopted by over 100 countries at the General Conference of UNESCO in 1997. and is probably the strongest international recognition of the importance of academic freedom. So, I mean, there's several themes we could pick up on. One, and perhaps just while you're on, Louis-Philippe, you had mentioned the controversy at the U of O over a faculty member who, in her course, in an academic context, used the N-word. One of the things that was interesting about that was the fundamental divide between academics in English Canada and Quebec and how they responded to it. There was large support for what the university did in English Canada, and I think it's fair to say there was considerable unhappiness with what the university did in Quebec amongst the Francophone academics. And I'm just wondering if you had any thoughts as to what that divide, the history or how that divide in dealing with what is one of the really thorny issues about freedom of expression on campus.
From my perspective, what was at the center of the controversy in Quebec was the fact that the professor was sanctioned by her university administration. So the fact that and it's the same thing when we're talking about freedom of expression. There's the possibility to sanction, and there's the possibility to use freedom of expression to discuss a controversy, to express and to try to convince a professor not to use anymore this word. And those kind of two levels of distinctions were at the center of the controversy from what was described again and again in Quebec as a crisis regarding the way that the Ottawa University administrations dealt with the situation within the Lieutenant Duval controversy. So it was less from... There was kind of the reaction of Prime Minister Legault was really an anti-woke position, and it was clearly his agenda when he put in place, again, from my perspective, the Commission Cloutier. But hopefully, not hopefully, but I'm really glad that the Commission Cloutier didn't fall into the trap. And so they didn't fall into the anti-woke agenda of the CAQ government, and they really issued an interesting and focused report on the academic freedom and what is needed to be able for professors and students at universities to be able to be engaged in the realization of the public interest mission of universities. So this is my take as why it was so controversial in Quebec, and in the from what I was able to hear. It was the fact that the professor, which it must be emphasized as well, she was a woman and she wasn't a permanent professor, and she was dealt with really differently than permanent staff for future controversies that happen at the same university. So that was at the center of the controversy for Quebec.
Thank you for sharing that. I mean, it's hard to have this discussion about freedom of expression on campus without focusing, and maybe we can turn to that now. There's been some mention of it, of what happened literally across the country last spring when there were student encampments with faculty involved and staff involved at, I think, 22 or 23 universities across the country. And they raised really in a very clear way a variety of issues related to expressive freedom. Universities handled them in very different ways. And as I mentioned at the outset, York and Laval and the University of Alberta and the University of Calgary almost immediately shut down their encampments in the two Alberta cases at the very least, with police and in some violence involved, and where there was no realistic right to or opportunity to engage in your freedom of expression or freedom of assembly. At other universities, the universities wanted to shut them down. They dragged out, I think at Toronto, before they got their injunction, it had gone on for 50 days. And there's an argument that, well, people did have the right to express their views even before it was shut down. And then at the University of Windsor, the university actually engaged, I think as McMaster did, in really good faith negotiations with the protesters to come out with a mutual agreement. Dick, you're from the University of Windsor. Do you have some sense of what played out at Windsor, and just to give people a sense of the other extreme from those that shut it down violently within 36 hours.
You know, to that question, Jim, I have to say no. I don't know how it played out because I just wasn't present. I never saw the encampment. I did see the encampment at the University of Toronto, and so I have a better sense of it, but I don't really have a good sense of how things unfolded at Windsor, so I'm sorry about that.
Well, I do know about the outcome of it. That is, there was a mutual agreement, and the encampment was taken down. And then the president of the university came under fierce attack from those who were hostile to the encampment for having reached an agreement. It was so fierce that he had to take a leave of absence, as did the director of human resources, as I understand. And he announced that he was then resigning as president at the end of this year.
Yeah, I'm aware that he took leave and that he's resigning, but I don't think it was ever said what the reasons or circumstances were. So I'm not really.
So, I mean, it was interesting, these wide range of responses to it. But the question it raises, and Jamie, you began addressing, and perhaps you could talk more about it, and Dick, you've written about it as well. Do students and faculty at a university have a right to protest on the university grounds, as happened with these encampments? Perhaps we could begin to open up. Jamie, do you have some thoughts on that?
Yes, well, I guess what I would say is that, to my mind, the encampments across Canada and the very, very different ways in which they went forward and were resolved or not resolved, it just showed to me the fragility of expressive freedom on university campuses, and the fragility of collective expression on campuses. This is not really an expressive freedom issue. It's an issue about gatherings, and it's an issue about the right to assemble in the public spaces of universities. And what, to my mind, I saw was just a huge vacuum on questions of entitlement, and how those questions of entitlement, the entitlement to set up an encampment, et cetera, could be regulated or dealt with by universities. And so you had this huge array across Canada where just in Toronto, for instance, the University of Toronto encampment was going for better than 50 days until the university was able to get an order from court requiring the encampment to disperse. So it was better than 50 days. And meanwhile, just up the street at York University, which is my home university, the encampment was down within 24 hours. And so, when I spoke earlier, I said, well, what kind of protection does freedom of expression or freedom of peaceful assembly have at universities outside the charter? And I think to my mind, it was not too much from what I saw through the encampment experience. If the university wanted to show respect for expressive freedom and peaceful assembly, it did. And if it didn't want to, it didn't. And so that's one of the reasons why I support the extension of the charter to universities, at least in this kind of a situation. I think it's there in principle. And I would just take a moment to say that I think the argument is even stronger in Ontario, where we have at least two instances of the provincial government exercising direct regulatory control over the colleges and universities. The first was a 2018 directive that required all colleges and universities to adopt a free speech policy and post it with the government that was in compliance with the Chicago principles, which I won't take the time to explain. And then the second you've mentioned was Bill 166, which was enacted recently, and again assumes direct government control over certain aspects of university governance related to free speech policy. And so those two measures, to my mind, create and establish the kind of government interference that engages the charter. And Dick probably wants to, and Louis-Philippe as well, probably want to comment on this. But the last thing I would say is that one of the things that I thought was interesting in the TMU report that was commissioned by the university after the student letter in the law school post October 7th, 2023. One of the things that was interesting in that report was that the judge found that TMU had adopted the charter. And I would say to other universities across Canada, give that a thought. Why wouldn't you? Why wouldn't you accept and adopt the responsibility to comply with the charter, at least insofar as we're talking about these kinds of expressive activities in public spaces on university property? I would have to work harder to figure out what that means, but the general principle is that there should be compliance with the charter in those kinds of spaces for these kinds of activities.
Jamie, the point you just raised is really an interesting one that I hadn't thought about and I hadn't realized. I mean, I read Justice McDonald's report.
Yeah, he did say
Just
that.
in the audience, there were a large number of students in the School of Law at Toronto Metropolitan University that shortly after the Hamas attack on Israel issued a statement that was critical of the Israeli response. And it was a very strong statement and led to a massive retaliation by the legal community. A number of the students who had positions in Toronto law firms were dismissed. Certain law firms announced they would never hire a student from TMU. There were demands that all those students be expelled. A donor from a law firm who had promised $1 million donation retracted it. And the university called in the former Chief Justice of the Nova Scotia Court of Appeal, Justice McDonald, to do the report that you were describing, Jamie. And in his report, so apparently he pointed out that TMU had embraced or voluntarily agreed to abide by the charter. That would be a wonderful initiative for anyone listening to our conversation to start raising with their own administrations, right? I mean, there's a lot of pressure to adopt various other statements and so forth. This would be a very interesting one. In any case, Dick, did you want to have some comments?
I mean, I think the first thing to note when we're talking about something like the encampment or protest on campus is that protests are, by their very nature, disruptive. So we start with a recognition that they're disruptive in character. At minimum, if you have any kind of physical protest, it's going to take up space and as a result, displace others. And certainly an encampment does that in a very clear, obvious, and ongoing way. So the really difficult question is how much disruption is too much? Or for how long is it acceptable or unacceptable for such disruption to continue? And reasonable people can disagree about that. And that's what makes it difficult. There's no simple answer to this went on too long or this took up too much space. And so I think that's the real challenge here, especially when we're asking university to try to define what's the appropriate limit to this, or courts to determine when something has gone on too long. So I think that's the first thing to take note of. I mean, it was certainly troubling when there was the suggestion that it's our property, the university, and therefore we can decide what happens to it. That really is not the starting point. And the starting point should be there is a right to engage in protest, to take up space, and the question always becomes, okay, how disruptive is it, and has it been disrupted for too long? If I could just follow up with Jamie on the question of the charter. Of course, we're talking not about the charter applying generally to universities, and Jamie noted that. Supreme Court of Canada said the charter doesn't apply. The university is not a government actor. The charter does not apply to the university as a consequence. But there's another thread in the court's jurisprudence around the application of the charter. The court said that even if an entity is not a government entity and is not by that subject to the charter, if it is carrying out government policy or government program of some kind, inasmuch and insofar as it's carrying out that program, its decisions related to that may be subject to the charter. So the courts of Alberta, for example, said when a university is regulating speech on campus, it is carrying out government-like activity and is subject to the charter. The courts in other provinces have not reached that conclusion, but we may get getting close to that. And as Jamie pointed out, there have been a number of actions taken by the provincial government in Ontario that have required the universities to put in place free speech policies and now to put in place policies in relation to hate speech or discriminatory speech. And that may be enough for us to say the government is directing the university to do certain things, regulate speech or not in certain ways, and therefore universities, at least in Ontario, may be, when they regulate speech on campus, subject to the charter, but only in that particular way or context.
Thank you for that, Dick. I mean, that's really important because, as some of the audience will know, there was a decision around some faculty who claimed that their charter rights were being violated by mandatory retirement that resulted in a decision known as McKinney, which left the impression the charter just full stop doesn't apply to the university. But as the question of all these publicly funded but non-government actors, when do they get covered? And they get covered just in the way you described, Dick. Louis-Philippe, did you have anything you wanted to add before we dig into this a little bit more?
Yes, because in Quebec, we were about to have a decision regarding whether or not the encampments were too much, too long, too harsh, because the specificity of the Quebec Charter is the fact that first it protects fundamental freedoms, it protects so freedom of speech, and it applies to Quebec private or public bodies. So it applies to universities.
The government.
Yeah, absolutely. So the fact that you are Walmart or you are Laval University or l'UQAM, they are all submitted to the Quebec Charter and the fact that they have to respect freedom of speech in a certain way. So when you're talking about a campus problem, quote unquote, we had our premier who from day one decided that property right was the answer. And so it wasn't normal. I'm quoting him, quoting, but I'm trying to. And so he was asking Montreal police forces to dismantle encampment from
You're
white. I'm freezing.
Okay, go ahead now.
Am I still there?
Yeah, you're here.
Okay, I'm back. They don't want me to do my point. I'm kind of being it's the Chinese government. Okay, so we're talking about the fact that even though the charter was applying, there was tremendous pressures to dismantle the encampment, and the Montreal police forces refused to the end to dismantle the encampment until they had a court order to force them to do so, because it was a private litigation, a private problem, and the charter was applicable because it was a public park. It was a public part of the McGill campus. And so there was kind of part appliances of the principles of freedom of speech to the encampments, the fact that freedom of speech doesn't allow you to express yourself in such a way that you are blocking access to buildings. And so in the UQAM case, they were able, because the administration was not pursuing the dismantlement of the encampment, they were pursuing the safety of the encampment, and they asked for the encampment to be, I guess, for a certain distance of the buildings, and they were able to get it because of the principles of freedom of speech, as a matter of fact. But because at the end, McGill decided to ask for private security force to dismantle the encampment, we weren't able to have a decision that would be really on the to go to the bottom of the problem that Richard was mentioning. So from what point is an encampment too harsh, and from what point an encampment on a public part of a campus has to be dismantled for security reasons, or for to allow the student and the faculty staff to enjoy this part of the campus as well. So the Quebec Charter was applicable. We almost got that decision, but we still have to rely on the Occupy few decisions that we have from the beginning of the 2000.
So, I mean, I think what's important going forward is that where, as Jamie and Dick described, where a government gives a directive to a university to act in a certain way that it spells out and which it often will attach penalties if the university doesn't, then that is likely, and as was pointed out in Alberta, was definitely cited in several Alberta Court of Appeal cases as bringing the university under the charter. I think that also actually has happened once in relation to a Saskatchewan Court of Appeal decision. So why do you think universities have been resistant to being covered by the charter? Because they have argued against the charter, the Canadian Charter of Rights and Freedoms applying to universities. Does any of you have a thought about why they've resisted that?
Well, doesn't it just make their life more difficult?
Yeah, they have to give up power.
Yeah, but when I
Be
read
vulnerable
Control,
to a constitutional challenge.
but when you look at their rhetoric, I read you the University of Toronto's statement of purpose in my introduction, which would make you think, and in the University of Toronto, to its credit, didn't shut it down right away. I mean, it went on for 50 days, but most universities would agree that they broadly subscribe to that vision, but yet they wouldn't want the charter to apply.
They think that they're self-reliant in this area and that they have the policies in place that adequately protect these kinds of freedoms, because all of the universities have them. I mean, if you look at the University of Toronto decision, the judge set out the various policies on expressive freedom at the University of Toronto, but these policies don't do very much to protect entitlements if the university is not prepared to respect them. And
that's the key, isn't it, Jamie? That university policy only works if the university wants to enforce it.
that's right.
Right,
Or
to adopt a very narrow reading of it too. I
Right,
mean,
right.
that's the question always.
I think in most of the encampments, what was cited was trespass law.
Right.
But there could be other, a lot of universities have policies on the timing and place and so forth of protests.
Louis-Philippe makes a very important point about what happened in Quebec, because dispersal should, in my opinion anyway, this is not law, but dispersal should be a last resort. And he mentioned that, was it at UQAM or was it at Laval that you're talking about the safety versus dispersal? And so they went with the less minimal restriction on the encampment. When dispersal gets rid of the whole gathering, lesser forms of regulation can look after safety issues or other kinds of issues about access by other members of the community without requiring the encampment to disperse. But as Dick was commenting, the duration of these encampments is an irritant, because the encampments, most of them were in place and they were going to stay there unless and until the university complied with their demands, which meant that they were indefinite in length. And so that, I believe that pushed the universities to a more militant position themselves, and to rely on trespass law and to look for dispersal rather than to look for ways of managing the encampment and, negotiating a durational term for the encampment.
But in the case of universities like Laval or Alberta or Calgary, where they shut them down almost immediately,
right?
When they were to claim, well, this was trespass and they had a right to do it immediately, I'm not sure that would hold, at least in Alberta, where there has been recognition of the charter applying to student expressive freedom rights. And it was interesting in the other interesting thing I found in the judgments that where there were injunction hearings is in the Toronto one, and you pointed this out to me, Jamie. One of the important things the judge did was to make clear that all of the claims that had been made by others in the community and sometimes by the university that there had been violence or had been anti-Semitism were without any foundation.
Mm.
So it was purely on the basis of trespass law that he made the decision he did. And I think it's really hard to find much evidence in any of them that these extravagant claims about violence or anti-Semitism have a factual basis. So it does bring it down more to the basic rights. If there had been violence, if there had been discrimination and harassment, then there would be legal grounds to bring them to an end, even with the charter applying. But in the absence of that, that charter protection would make a big difference. So I still continue. I mean, I'm still caught between the strong affirmation of expressive freedom rights that most universities have in their policies and so on, and their disinclination to allow those rights to be used. We're going to turn to the audience in a minute, but Jamie, I'd like to just give you one more. You applied several times about there are actually two rights involved here: freedom of expression and freedom of assembly. And you've written what I think is a wonderful blog post on the CFE blog about how freedom of assembly is not just collective freedom of expression, but it's a right that stands on its own. Could you just comment on that before we turn to the audience for questions?
Yeah, I'll try to do this briefly.
I'm sorry to ask you this complex.
No, it's okay. I mean, I'm speaking only for myself. I ignored freedom of peaceful assembly for like 40 years as an academic. And then it was only in my involvement with the Rouleau Commission and the Freedom Convoy that I started to think it through a little bit more. And I came to the realization that freedom of peaceful assembly is not just the +1 of expressive freedom. It's an entirely different entitlement that has its own underlying values and makes its own contribution to participatory democratic discourse. And what's different about peaceful assembly is that it is necessarily spatial in nature. I mean, expressive freedom doesn't necessarily require space for its exercise, but peaceful assembly or assembly rights do. And so they can only take place if they have a space in which to gather. The right can only be exercised in a physical space. But the other thing about assembly is that, and I think it was Louis-Philippe or maybe Dick who already said that, we have to remember that assemblies are disruptive in nature. Their purpose is to be transgressive, and it's because it's a form of engagement that joins voices in solidarity in order to make a performative, to create a performative presence and communicate a message. And when we start to talk about it in that way, I think we begin to see that it's a different constitutional animal than freedom of expression. The problem with the jurisprudence up to this point in time is that whenever there is discussion of any kind of assembly rights, they just get dropped back down into Section 2B, where their essential qualities cannot be recognized, in my opinion, under the Section 2B doctrine. So I'm a big booster of developing a Section 2C jurisprudence, and I think it's a very great oversight in the Charter's evolution in the first 40 years. So,
thank you, Dick. Did you want to add anything to that or comment on that?
No. Yeah. Jamie knows I've been very much a Section 2B imperialist anyway. And was
I know.
to see all things encompassed within it, but I certainly, I know. I mean, I will say and acknowledge that a focus on freedom of assembly at least is a way of highlighting the disruptive character of this kind of expression when it takes the form of a collective gathering to protest in some way. And so at least it does highlight the fact that there will be some disruption here and that that's a legitimate part of that kind of protected activity.
And Louis-Philippe, did you want to add anything?
I totally agree with Jamie, as a matter of fact, because I think that it's like an absent, it's a ghost. 2C is a ghost in the fundamental freedoms disposition of the Constitution. But as a matter of fact, if you go to the 1987 trilogy about freedom of association and the fact the evolution of the Supreme Court towards the acceptance that freedom of association may protect collective activities, I think that now maybe the in French, we say le fruit est mûr, so that 2C may be used for collective activities, like for the moment that were put into the scope of 2B with the freedom of speech. Because what if you're the distinction between freedom of speech at 2B and freedom of assembly at 2C is the collective part of that is essential at the heart of 2C. And so it's kind of a by default that we were able to protect protest through 2B from the beginning of the jurisprudence, the charter jurisprudence.
We're going to turn to the audience now, but for Dick, it's after 1 a.m. So if you're able to stay, that's fine. If you're not able to stay,
I think also I have commitments tomorrow. So thank you, everyone. I apologize for dropping out here.
We're
Good night,
1 in the
Dick.
morning is
See you
a
soon.
sacrifice.
Thank you.
Ange, what's the first question from the audience?
Yeah, the first question, I do want to remind people that you can use the Q&A button to ask questions of Jim, Jamie, and Louis-Philippe. The first question from an attendee, they ask, how do we reconcile calls for any critique of the state of Israel as anti-Semitic and thereby considered to be hate speech in university settings?
Okay. Who would like to start? I think all of us would want to comment on that. Jamie or Louis-Philippe, would you like to begin? Or while you're thinking, I'll certainly start. I mean, where I thought the question was going was to comment on the call for the universities to adopt the International Holocaust Remembrance Alliance definition of anti-Semitism, which brings criticism of Israel or of Zionism potentially under the auspices of anti-Semitism. And that's highly controversial. But whether being critical of a government constitutes hate speech, I think is the heart of that question. Could you just read the question one more time so I make sure we're not misinterpreting it?
Yeah, they ask, how do we reconcile calls for any critique of the state of Israel as anti-Semitic and thereby considered to be hate speech, especially in university settings?
So are there grounds under which criticism of the government of Israel, as opposed to criticism of Jews collectively, would be considered hate speech in any legal way in Canada?
I think it's a stretch because the criteria are pretty severe to be able to be defined as hate speech to the Watcott case and the jurisprudence to I think it's section 219 of the criminal code. So I would say personally that is a stretch.
I would just sort of add that the definitional scope of what is or is not anti-Semitic is an issue on which there is a very wide divergence of views, at least as far as I'm aware. And again, we go back to the question that I began with when I was talking about freedom of expression. You know, when we're looking at difficult questions like this, and it is a difficult question. I mean, I think there is a lot of anti-Semitism out there. This difficult question, you have to look very carefully at what is being sought to be regulated, which is expressive activity, and what the harm is that the activity is causing. I didn't say that very well, but you know, there's a very difficult issue that has to be addressed there. And one of the things that was interesting to me was the way the judge in the University of Toronto encampment case dealt with particular slogans that were seen around the encampment that were argued to be anti-Semitic in nature. And I thought he did a pretty good job of providing a balanced discussion in sorting out what is, as a matter of legal definition, anti-Semitic and what is not. Now, he did come down on the side of expressive freedom, and many others would not agree with that. But so I'm not resolving anything here except to agree that it's a very difficult issue. But personally, I'm cautious about giving too broad a scope to definitions of anti-Semitism or definitions of any other kind of offensive expression for that matter. I don't know if that answers the question, but I'll stop.
Isn't it fair to say that our courts have been pretty consistent in saying there's a very high bar that has to be gotten over before expression is considered hate speech under 319.1 or 319.2 of the Criminal Code?
Sure. I mean, there is that high threshold for hate speech, but to the extent that there are now, the institutions are now adopting definitions of anti-Semitism, so on, is not strictly an issue of hate speech. And there are other definitions out there that universities are acting on to restrict expressive activity. It's not only hate speech.
Right. I mean, I mentioned the hate speech because the question
Yeah, that's the question.
raising it as an instance of hate speech. Okay, Ange, do you have a second question?
Yeah, the next question is from Spiros. Even if the charter does not apply, do charter values nonetheless apply to university policies enacted through the authority conferred under enabling legislation via administrative law principles?
So would one of you like to explain what charter values are and how they might or might not apply in this instance?
How long do you have?
Well, I mean, this is the problem with their questions like that.
Yeah.
They really begin with a very important issue, but one that I think it's important for the audience to have some grasp of.
Do you want to do it, Louis-Philippe, or?
I can begin the beginning of an answer. I would say that those kind of question just underlines the importance if you're going to go through the charter to protect academic freedom and if you're going to make a case about the fact that the charter should apply to universities, it must be done with the recognition, the express recognition of academic freedom as an institutional guarantee. And it's quite complex because in the McKinney case, this is in part why the court decided that the charter wasn't applicable to the university, because it's kind of a independent institution, which is a part of academic freedom. So this whole paradox when the Quebec Federation of University Professors were thinking about, should we ask the government to pass a law protecting academic freedom in a context that we don't want the government to interfere into academic and university affairs? So I guess that if you just go with the application of the charter to universities and you're not adding to this case the express recognition of the principles of the 1997 recommendation on academic freedom, especially the autonomy of universities and the interpretation of freedom of speech inside the university, there's kind of the charter values can contradict the necessary independence of universities in the way that they are dealing with the problems that may relate with the exercise of freedom of speech of student or faculty staff or professors inside the university. So I guess it's a really, really delicate balance. And the fact that for the moment in the jurisprudence, we have the charter jurisprudence, little signs of what is protected by academic freedom. And this is why I decided a few years ago to invest myself into research regarding academic freedom, because I realized that even for our own colleagues, they don't really know what is and not academic freedom, because there's a lot of definitions that are going through the academic world. And this is the weakness of the fact that for the moment, in the rest of Canada, we have the law in Quebec, but for the rest of Canada, the protection of academic freedom is through collective agreements. And so that means that it's only the individual part of academic freedom that is protected by collective agreements. except some exceptions, because the institutional part has to be protected by the university as an institution. So maybe in policies or, and that may be a really good addition to the case that the charters must be applicable to universities. But the danger may be mitigated by the fact that you are going forward with those two sides at the same time, the application of the charter to universities and the express recognition of academic freedom as an institutional guarantee.
Jamie,
I
I'm going to want to come back to you in a minute about charter values, but I do want to. This is an issue that Louis-Philippe and I have discussed on many occasions. Whereas I don't see institutional autonomy as related to academic freedom. That is, institutional autonomy points to an important principle that governments can't be under the thumb of politicians. The universities can't be under the thumbs of politicians and governments. On the other hand, a good deal of threats to academic freedom have not come from outside the university, but have come from within the university, from administrations, from colleagues, from students. And so university autonomy in that sense, it's like saying, well, we're going to protect academic freedom by building a moat around the university. But in fact, if the arrows are coming from within the university, that autonomy can be used to suppress individual academic freedom rather than protect it. So it's how do you have a balance that recognizes the importance of institutional autonomy, but allows for some outside intervention through the courts where that academic freedom is imperiled by the institutional autonomy, that is its policies and its enforcement. So it gets into
This,
yeah, I don't think we disagree on that. It's just
I know.
how to sort that out. But the questioner asked more about the concept of charter values and its could you tell us, Jamie, just what charter values refers to?
Well, what I would like to say about charter values is that it's kind of a technical question, what the charter values are and when they apply and so on, but they are well, I'm going to say they're a second best to the charter, and the charter values apply in circumstances where the charter does not directly apply, but the idea is that the charter values have traction and are in the court's own language as robust as the charter. Now that's challenged on a regular basis by people who think about these things. And all I really want to say about charter values in the university is that, and I keep going back to the University of Toronto encampment decision, there the judge didn't look at the charter issue because it was not procedurally before him, but he included an appendix decision on the charter, and he found that the charter was not applicable to protect the rights of the encampment. And so he, having made that finding, those findings, the Obiter one and the one that the charter couldn't be applied because it was not technically before him, he turned to charter values. Basically what he did was to look at the university policies and to say, and I apologize, I'm on vacation, I don't have it in front of me. He said things like the university policies are directionally similar to charter values. And he used that kind of language and then went on to apply the trespass law without any accommodation for expressive freedom or the rights of the encampment. And so a long-winded answer to say, I don't have very much confidence in charter values as a way in this context of protecting the rights of expressive freedom and peaceful assembly on campus, because there is not the same sort of framework that requires an analysis that is capable of protecting the entitlements. Others might disagree, but that's just my view.
Thank you very much. Ange, the next question, please.
Yeah, the next question is from Carolyn. And Carolyn asks, could the panelists talk about what it means for any university president in Canada ever to authorize the use of police force against protesters on a campus? What are the larger implications for students, faculty, and university communities?
That's actually a question for you, Jim, because you're working on this.
Well, no, but go ahead. I don't have the law credentials either you or Louis-Philippe has, so I'd prefer you to comment first.
Well, I don't know. I have a fairly simple view of things. It seems to me that when the police come onto campus, the charter is engaged, whether it's through the auspices of a university president or not. So when the police come onto campus at the request of the university president, it seems to me that they're subject to the charter and are required to comply with the provisions of the charter, such as section 2B, 2C, section 8, whatever else is on the go in the particular situation. And as for the university presidents who request the police to come in and disperse encampments, again, we're back to the question of whether the charter applies. And I have views about that, as you've already heard.
Louis-Philippe, do you have anything you wanted to say?
But I would say that symbolically, at least, it's a breach of the institutional guarantee, the fact that you are requesting the intervention of the police, and especially like it was the case at the McGill encampment situation, because it was from day 1 or 2 that they were asking the police to intervene and to dismantle the encampment because of property, right? And so they weren't giving any consideration from the fact that those were student encampment, so members of their own communities. And so we weren't in a position, I'm talking about the administration, that they were considering negotiation first and last resort options to turn to courts and to turn to police to obtain the dismantlement of the encampment if there were security breaches or problems that they weren't able to deal with. But it was reinstated again and again. There was 2 injunction attempts by the McGill direction, not to by the McGill administration, but one by the McGill administration, another one by member of the communities. And each time it wasn't proven that there was security problems with those encampments. So I would say that symbolically, there's a major problem with the intervention of police forces. And if you look at the way UQAM administration dealt with the encampment, it was a total success because they didn't ask for the court to dismantle the encampment. They asked for it to be safe for the community and to the protesters. And at the end, they were able to obtain a negotiated deal. It was the protesters who decided from themselves but to abandon the encampment. So, yeah, it's problematic from the legitimacy standpoint if you're talking about what should be a university and what distinguishes a university from a Walmart.
Well, you've made it easy for me to add my comment to this because I agree with both of you. I mean, I think when a university administration calls in the police within hours of an encampment being set up, regardless of what kinds of policies they have, it's a total disregard for free expression rights and freedom of assembly rights. Arguably is a violation of the charter, since the police, I take it, are agents of government who are being brought in by the university to act. And so it's really a deplorable situation. When it happens before the encampment has even had a chance to set up and do anything. I mean, as you mentioned, Jamie, at U of T and some other places where it finally got settled through court intervention or whatever, it was after a long period of time when there was arguably a lot of opportunity to express themselves. But at Alberta and at Calgary, there was no opportunity, as there was not at York or Laval.
You know, and if you, maybe not so much in a university setting, but I mean, the better view is that police actually have a duty to protect those who are engaged in the legitimate exercise of freedom of peaceful assembly. And you can think back to the incident, I think it was in Los Angeles last spring, where the police stood by and allowed thugs who had come in from outside to commit acts of violence against those who were members of the university committee and were engaged in a form of protest demonstration. So there's a lot to think about in this whole area about police authority, but also the duties of the police and the responsibilities of the police toward those who are engaged in legitimate forms of protest.
Thank you.
And this is especially why the Montreal police forces refused to intervene at McGill's, even though the premier was asking them repeatedly, our Minister of Higher Education as well, and McGill administration. The answer of the Montreal police forces were to say, if we have a court order, we'll do it. But since then, it's a legitimate protest, and we're waiting it out, and we're just assuring that everyone is safe.
Mm-hmm. Okay, Ange, do you have one more?
Yeah, the next question, and it came in from a similar question from a couple people. This one is from Kenneth. Kenneth says, I'm not a lawyer, but it seems to me the question is whether enshrining protections for university and the charter would be sufficient to defend them in relation to the law of trespass, which is the key location of tension in relation to the gatherings, such as encampments.
So is it fair to say the question would be, in the case of Toronto, if it were clear that the charter applied, what happens when the university maintains the land is being trespassed upon, and the protesters say, well, we're exercising our rights of freedom of expression and freedom of assembly? How would a court deal with that? Those conflicts. Is that the essence of the question, Ange, do you think?
Yeah, I think it's about the tensions between those two. And yes, that's essentially what people are asking.
I would say I'm not confident the result would change, because I don't think that there's a very strong appreciation of rights of protest and demonstration anywhere in the charter jurisprudence, regardless whether it's happening on a campus or in public space that is owned, in public space that is unquestionably subject to the charter because it's owned by the government. So, we've got no time to talk about the convoy, but, I'm not confident the result would have changed. And I think there's a lot of sympathy on the part of the court in the University of Toronto case to the university, because it was being deprived of its authority as the owner of the property to allow other members of the community to use and enjoy that property, the property in that field that was where the encampment was taking place.
So is that really an observation that the protections, the recognition in our jurisprudence for the fundamental freedom of expression and freedom of assembly is not as robust as it might be?
Exactly.
Louis-Philippe?
It would have been really interesting to have a decision at the, we're talking in French about le fond de l'affaire in the McGill case, because we would have been able to have an answer. It was two temporary injunctions, and the trespassing laws weren't enough for the court to say, yeah, there's an emergency and we will order the dismantlement of the encampment. Because, and I think that those are the limits of the trespassing arguments from two perspectives. First, what do you do about trespassing when the field is occupied by a member of your own community? Because if you're talking about student encampments, they have the right to be on campus because they are a member of the community at first. And second one, there's this kind of hybrid kind of fields, because it's like public parks. So the law is really clear. You cannot establish an encampment inside a building. You cannot establish an encampment blocking access to a building. So it's not protected through free speech. So, or it will be considered as reasonable limit to free speech if you are ordering a dismantlement of those kind of activity. But if you are, like it was the case at McGill, and the Quebec Charter was applicable, if you are using a public part of the campus to establish an encampment, and you're not blocking access to any buildings, and you're not blocking access to any members of faculty to be able to do their work inside the campus, the fact that the university was deprived of the capacity to enjoy access to the full field wasn't considered enough at the stage of the two temporary injunctions. So it would have been really interesting to have a decision on a permanent injunction, but security forces intervened before.
Well, listen, I want to thank the two of you and Dick in absentia for this really engaging discussion tonight. It was a real pleasure to have you on our panel, and I think it was quite an important discussion that you shared with everyone. And I want to tell everyone that tomorrow we're going to post the video of this conversation on the CFE website, and we're also going to post a list of resources that we made reference to here, and other things for any of you who would like to dig more deeply into these issues. So we'll put up the link to the UNESCO recommendation on the status of higher education personnel with the part on academic freedom, the links to the judge's decision that we've made reference to at the University of Toronto, some of the blog posts of Dick and Jamie, writings, anything that Louis-Philippe would like to share, so that you will have an opportunity. So that'll be on the CFE website tomorrow. And that website is CFE, for Center for Free Expression, cfe.torontomu.ca. Our next event is going to be a week from tomorrow. That's on Wednesday, February 5th. It's going to be quite an interesting one. It's featuring the very eminent Canadian author, Lawrence Hill, whose recent book, The Book of Negroes, award-winning book, was banned by the London Catholic District School Board because Hill used the N-word in it. Lawrence will be in conversation with Deborah Thompson, who's a McGill political scientist and author of her memoir, The Long Road Home on Blackness and Belonging. And the title of the session is, quote, "We can't teach a book that has that word in it," end quote. And it's going to be reflections on the role of literature in society. So that's going to be next Wednesday, a week tomorrow at 7 p.m. Eastern Time. And you can find all the details about it on our website, as well as the video of today's session, which, if you enjoyed, I hope you'll draw attention to your friends and colleagues to it. Thank you very much for joining us tonight. And again, thank you to the panel, and thanks, Ange, for her hard work. Good night, everyone.
Good night, everyone. Thanks.